Hello everyone. My name is Michelle Dang. Right now I'm sitting in Vietnam. I'm traveling international. Um, so I'm going to talk about the case of Scott D. Clark, CPA, um, and EY is the auditor of Cintas. So the purpose of this presentation is to observe the public feelings surrounding and relating to an individual CPA that has been sanctioned by the SEC or another state board of accountancy. Using public feelings, we are trying to get a better understanding as to why the person in the question did what they did so that we can avoid similar pitfalls as we start our careers in public accounting. So, especially with me, I'm taking this class to learn from the case that happened and happening. So I can learn from mistakes from people so I can avoid it when I have planned becoming a CPA in the future. And another is that presentation will also include assumptions so that we can get a better understanding as to why the individual did what they did. And again, the topic I select is Scott D. Clark, CPA. He was 61 years old. Um, he was he was 61 years old at the time happened. He was a task manager, task director, and vice president of Cintas Corporation since 2000. And this case was bring to the court in December 10, 2021. And he was retired from the Cintas Corporation in 2020. He lives in Ohio and is still living there. He had a CPA license in Ohio, but not have a permit to engage in public practice. So the next thing, I'm going to go through some background of Scott D. Clark before he worked at the Cintas Corporation. He attended University of Cincinnati. He got a Bachelor of Business Administration with accounting major from 1978 to 1983, and he graduated. Then I couldn't find any information before he worked for Cintas. Even though I sure you can see I attached his Lincoln, and he didn't mention any information before he worked for Cintas Corporation. So he worked as a vice president corporate taxation excuse me, and task director, task manager from 1991 to September 2020. And after the incident, I will go over later. Yeah, okay. So the summary of the incident, that this matter involves adding, abetting, and causing violation of the auditor independence rules arising from EY LLP, a public accounting firm, performing non-audit services for its audit client Cintas Corporation on a contingent fee basis for tax credit and incentive service, we can call CNI services, performed between July 2009 and August 2018. So the EY provide the service, audit service to Cintas from 1968. but EY started to perform non-audit services from July 2009 to August 2018. An audit firm is not independent of its audit client if it provides any non-audit services to the audit client for a contingent fee. As a result, EY was not independent of Cintas during that period. So who is Scott D. Clark? Scott D. Clark is a respondent in this case. He is a certified public accountant, where Cintas vice president of corporation taxation. Throughout the both time period, respondent approved on behalf of Cintas the payment of the invoice for EY C&I services calculated on a contingent fee basis, about 10% for each year. As a result of his conduct, respondent willfully added and abetted and caused Cintas to violate the Exchange Act Section 13A and Rules 13A-1 and 13A-13, which require the company to file annual and quarterly reports audited and reviewed by an independent public accountant. Moreover, respondent willfully added and abetted and caused Cintas violation of the federal securities laws within the meaning of the Section 4C(a)(3) of the Exchange Act and Rule 102(e)(1) I of the Commission Rules of Practice. And I also attached the link of the case, so you can read more information about the case with the link. Going next, from when I read this incident, I have some personal thoughts that EY had to obtain pre-approval from Cintas Audit Committee under Section 10A(h) of the Exchange Act in order to provide non-audit tax service to Cintas. Note that EY complied with the PCAOB Rule 3524, which requires written disclosure of a fee structure that complies with auditor independence rules. This policy and procedures. After presentation from EY, the engagement letter was signed by both management and audit committee relating to the bill the C&I services on a time and materials basis. Then Scott was aware of the audit committee presentation and signed engagement letter after reviewing. And the incident also mentioned that Scott know that the independence rules that EY shouldn't provide non-audit services to Cintas with contingent fee. So my question is, so he knew it and he actually not aware of how serious about the law when he violate the law, or he just thought that, oh, maybe as easy or no one will know about this. So we don't know. And my second thought is that, so why SEC only force punish the vice president, task director, and task manager, who is Scott D. Clark, who hold the key position. So how about the committee? How about the managers? So all the people involved in this. So my question, SEC only punish the CPA? So this is my question in my mind that I don't know. Maybe I will do more research to answer my question. But that's something we can think about. So what laws were violated in this incident? So Scott violated the section 4C and 21C of the SEC of 1934 and rules 102E1 I of the Commission Rules of Practice. So the section 4C provides that the commission may censure any person or deny temporary or permanent to any person the privilege of appearing or practicing before a commission in any way if that person is found not to post the requisites, the qualification to represent others. And I think it's got it. And number two is to be lacking of the character or integrity or to have engaged in unethical or improper professional conduct. So I think in this instance, Scott knew that EY is violate the independent rules, but he still approve and continue approve on payment the invoice to EY. And number three is to have a willfully violated or willfully added or abetted the violation of any provision of the securities law, the rules and regulation issued thereunder. How about Rule 102E1 I provides that the commission may censure a person or deny temporary or permanently the privilege of appearance or practicing before it in any way to any person who is found by the commission after notice and opportunity for hearing in the matter to have a willfully violated or willfully added and abetted the violation of any provision of the federal securities law or the rules and regulation thereunder. I also did the research about the rules of 102 because it doesn't include in the incident file. So you can read more rules with attached file attached link. What is a firm policy relating to this incident? So the firm policy is that the high key positions such as manager, director, vice president, CEO, CFO have to be responsible for managing and giving the right decision for the company. So this case, Scott was the task manager, task director, and vice president for the corporation taxation. So he would respond for a decision relating to tax departure, and he was a CPA too. So Scotty Clark, he should, if he did the right thing in this case, that when he knew, so when he knew that EY violate the independent rules, that EY shouldn't provide the non-audit services to Cintas with the contingent fee basic because EY did the audit to Cintas. So if he knew about this and he knew how serious about the independent rules, that if he didn't follow, he will get the punishment from SEC and which affect his career, especially he may lose his CPA license. So when he knew about this, I think he should didn't approve to pay EY with contingent fee, maybe a different way, maybe charge per hourly, many ways, but not contingent fee. Or he should tell EY about this, and he didn't approve the payment, or he didn't approve the when EY present about this. So if he did the right thing, he would not get punishment when the everyone know about this. So I think this is the lesson for the high position in the companies nowadays. Moving next, so what was the punishment by the SEC to Scott D. Clark? Within 14 days from the other respondent pays a civil money penalty of 30,000 to the SEC. Many ways by electricity, direct payment from the bank account or cashier check anyway, but need to pay within 14 days. The next thing, the respondent was denied the privilege of appearance and practicing before commission as an accountant. For example, he cannot be CFO. An auditor provides service as an auditor who signed the other paperwork. So after 1 year from this order, he may ask for reinstatement by submitting an application to the attention of the officer of the shop accountant. Respondents shall provide an explanation as a facts and circumstance to the matter. If commission has discovered contrary information or respondent is not able to provide the documentation and truthful and accurate attestations. Punished by Ohio State. So because I'm traveling international right now, so I cannot trust on the Ohio State Board of Accountancy. Sorry about that. And beside Scott D. Clark, I also did some research and SEC's order against 3 people from EY relating to this incident. So first person is Phillips Horak, an attorney and former EY engagement manager who approved EY invoice sent to Cintas containing contingent fee for non-audit services for several years. And when within 3 people from EY, I think Philip is the least person should get a punishment from this incident because I think he had the least change to know about the independent rules when he's the attorney. Maybe he doesn't know about the other independent rules as an auditor, and his engagement manager, maybe he didn't know, but he should get in charge or responsible for some of this incident. So I agree with the punishment, but that's just my thought. And the second question is Adam Buring, who is also attorney and the EY engagement partner for the non-audit services. So he failed to perform a reasonable inquiry in response to information that staff under his supervision will be within tasks for non-audit services on a contingent fee and did not stop the practice. The third person is Alan Greenwell, a licensed CPA and the former EY partner who engaged in improper professional conduct within the SEC rules of practice by failing to investigate red flags and regarding the contingent fee arrangement. So I think the person, when they become a partner, they should know well about the independence rules, especially the work in public accounting. And post-incident of D. Clark, Scott D. Clark, that after the incident he retired, even though posted the announcement of his retirement from Cintas Corporation in 2020 in his LinkedIn profile. His After the incident, after that, and he's still working as a manager for Kelly Clark Design, his wife's interior design services after the incident to the Bizan. So you can find his LinkedIn profile I attached in this. And then finally, personal thoughts after reading this incident that the SEC does not mess around. Initially showing as greedy, and SEC should against relating to people so that people can learn from this case. So they seriously use the law in their practice, especially CPA working in public accounting. However, this case gives me a second thought that Scott may not know about how serious consequence of the independent rules when violating this rule. He may take things more serious if he haven't been an auditor or working a public accounting firm. Thank you for listening.